You ready?
Yep.
I am going to ask you certain questions, obviously, about this lawsuit that you have brought, and I am going to start with a few questions that go back to the 80s or so. Let me start from a little bit before that. You were diagnosed with diabetes sometime when you were in your mid-20s? Yes. You had that condition for a period of time, and then there came a time that you became diabetic, is that correct? Yes. And in addition to the diabetes, as you understand it, there were other conditions relating to it that you were experiencing sometime in the 1980s. Is that a fair statement? Yes. It is a condition known as diabetes neuropathy. No, it is diabetic neuropathy. Diabetic neuropathy, I stand corrected, and there would be times when you had difficulty feeling certain portions of your body. Would that be true? Yes. Now, Mr. Maz testified yesterday here, and he used a term that we discussed together. The term was baseline. Are you familiar with that term? Defendant's counsel, objection, immaterial. The court overruled. No. Wouldn't you agree with me that there were times in the late 80s and 90s when you were feeling worse than you generally felt, and they were treated or termed exacerbations? Yes. And then after the exacerbation was over or completed, you returned back to your normal state? Yes. And Dr. Maz described that as being, that was your baseline, what you returned to after an exacerbation. Well, okay, roughly that is what we discussed, okay? Okay. Now we would like to discuss that baseline with you. Am I correct that you were in reasonably good health until approximately, let's say, 88 or 89? Yes. You had diabetes? Right. Took insulin? Yes. Had an episode or two, but you were functioning independently at that time? Yes. When I say independently, you walked without any assistance, played golf, had a social life, went out with your wife, had a normal husband-wife relationship, and all those other things that went with living. Yes. You were not disabled up until that point? Until that point, yes. Now, between 89 and 91, that condition changed dramatically, did it not? Defendant's counsel, just note my objection to the form of the question. I just have a problem with the word dramatically. The court, fair enough, let's define our terms. That condition changed? Yes, it did. It changed substantially? The court, let's talk about how it changed. Plaintiff's counsel, withdrawn. It changed? Yes. In those 2 or 3 years, you went from a person that was playing golf to not playing golf, right? No, I had an exacerbation in November of 89. It was then that the doctor that I was seeing at the time, Dr. Blau, a neurologist, said that there was a possibility that what I had was not diabetic neuropathy, but was MS. And that was the first I heard of MS. What year? November of 89 or December of 89. Let's take January of 90 then, okay? Yes. Between January of 90, when you say you were functioning actively, relatively normally, I came out of that exacerbation with a little bit of a limp, but I was still playing golf and going to my country club, yes. Then let's take January of 90 on, and let's take you up to the fall. When I say before Mercy, you know, and this jury knows, you were in Mercy on 2 occasions, twice in 91 and once in 93, correct? Yes. So when I say before Mercy, I am going to refer to the Mercy admission of 93, which is part of this case. Right. And when I say pre-fall, meaning before you fell, I am talking roughly the same time. So let's take those 3 years then, Mr. Bland, between roughly the late part of 89 or January of 90 up until the beginning of 93. All right? Yes. Your condition changed from being walking without assistance, without any help, driving a car without assistance, without any special instrumentation, from living a life with your wife socially and so forth. You went from that to something else, right? Yes. You saw at the beginning of that period of time, January or so of 90, you saw Dr. Wren for the first time? Yes. He confirmed your diagnosis of multiple sclerosis, correct? Yes. And he told you you had progressive MS, fair statement? Yes, I think that was what he said. At the time you saw him, you were using a cane to assist yourself in walking, true? Could possibly be, yes. Around that time period, believe me, these are not trick questions. No, I understand. Roughly that period of time? Yes, this was right after the 89 exacerbation, which had not gone away completely. During those 3 years, you went to Dr. Wren. He told you you had progressive MS. You were obviously concerned. And by the way, if during the course of this examination that I am conducting with you, if you have to take a few minutes, please tell us, okay? Fine. You were concerned about what this disease was going to do to you over the years when you went to see Dr. Maz. True? Yes. In other words, he could not tell you that what you were then doing was the worst you would ever be. Fair statement? Defendant's counsel, objection. The court sustained. Did he tell you that this condition could get worse? Defendant's counsel, Your Honor, I'm going to object to what Dr. Wren said as being hearsay. We had Dr. Wren here yesterday, the court. I'm going to permit the witness to answer the question in the context of what he recalls about any specific conversation with Dr. Maz. Let's set a time and place as best we can, and let's go from there. Defendant's counsel, may I just note an exception for the record, Your Honor? The court, yes. Other.
It's okay.
You got a pen there?
No.
Okay, let's get that. Okay. Right, ready?
Yeah.
Lionel Simpson appeals the setting of his bond at $600,000. Ex parte Lionel Simpson, we delivered an opinion which held that a previous $1 million bond was excessive. We remanded the matter back to the trial court for a hearing to reconsider the issue of bail. This appeal is from that hearing. Defendant raised 3 issues. Defendant was indicted along with others for capital murder. At the time of the alleged offense, appellant was a minor. He was certified as an adult for purposes of trial. He has been in custody for approximately 18 months. At the original writ of habeas corpus hearing, there was evidence that his family could possibly raise $3,000. Also, there was testimony that he was a lifelong resident of Anderson County and would live with his mother if released on bond. At the hearing that is before us now, he testified that his financial condition had not changed and that he had no financial resources. Further, he advised the trial court upon request that his client had attended school through the 9th grade. The state introduced copies of letters that he had written in jail to his girlfriends, sisters, and his brother, who previously received the death penalty for the same offense. The purpose of the evidence was to show that the defendant was a member of a violent gang, a danger to the community, and a flight risk. Appellant denied any gang membership. As noted by the trial court, the letters are incredibly shocking. They portray an individual with a violent and unrepentant nature. Defendant wrote only of violence, sex, drugs, and partying, and he bragged about his bad reputation. A Palestine police officer testified that he admitted to him that he was a member of a gang in Palestine known as the Southside Crips, a gang known for a wide range of violent crimes against the community. We will review the trial court's decision based on an abuse of discretion standard. A trial court abused its discretion when it either renders an arbitrary and unreasonable opinion or acts without reference to any guiding principles and rules. The primary purpose of an appearance bond is to secure the presence of the defendant in court. Historically and constitutionally, bail balances the presumption of innocence of the accused with the compelling interest of the state that the accused appear to answer the accusation against him. Bail should not be excessive as to guarantee the defendant's appearance, but only to give a reasonable assurance that the defendant will appear at trial. The person seeking the reduction has the burden of demonstrating the bail set is excessive. In determining the amount of bail to set, the trial court shall be guided by the following rules. 1. Bail shall be sufficiently high to give reasonable assurance the undertaking will be complied with. 2. The power to require bail is not to be so used as to make it an instrument of oppression. 3. The nature of the offense and the circumstances under which it was committed are to be considered. 4. The accused's ability to make bail is to be regarded, and proof may be taken upon this point. And 5. The future safety of the victim of the alleged offense and the community shall be considered. Circumstances to be considered in determining the amount of bail included the accused's work record, family and community ties, conformity with the conditions of any previous bond, as well as the existence of any outstanding bonds and aggravating circumstances involved in the charged offense. Ex rel. Ruback, 611, Southwestern Reports, 2nd, 848, 849-50, Texas Criminal Appeal, Panel 1981. Defendant asks this court to reduce his bond to no greater than $40,000, alleging that he has no assets and his family's financial resources are limited. However, the ability of an accused to post bond is merely one factor to be considered in determining the appropriate bail. See Ex parte Vance, 608, Southwestern Reports, 2nd, 681, 683, Texas Criminal Appeal, Panel 1980. Charles Worth, 600 Southwestern 2nd at 317. Simply because a defendant cannot meet the bond set by the trial court does not automatically render the bail excessive. If the ability to make bond in a specified amount controlled, then the role of the trial court in setting bond would be completely eliminated, and the accused would be in the unique posture of determining what his bond should be. Ex parte Miller, 631 Southwestern 2nd, 825, 827, Texas Appellate, Fort Worth, 1982, petitioner referred. The amount of bail must also be based on the nature of the offense and the circumstances under which it was committed. See Ex rel. Davila, 623 Southwestern 2nd, 408, 410, Texas Criminal Appellate, a Panel of Opinion, 1981. In the instant case, the nature of the offense is a brutal gang-related murder. The circumstances of the offense, as set forth in the indictment and other records before us, depict a violent, unprovoked killing and suggest an appalling lack of concern for human life. If convicted, appellant faces life imprisonment. Regarding appellant's assertion that the amount of bail in the present case is so high as to make it an instrument of oppression, we note that this factor may be analyzed by looking at the amount of bail in relation to bonds set for the other crimes. Ex rel. Emery, 970, W. Second, 144, 146. We have not reviewed other cases in which similar amount of bonds have been reduced, but recognize that in many of these cases, the facts and circumstances surrounding the crime were not developed at the hearing on the application for writ of habeas corpus. How's that?
It was pretty good. There were a couple citations where I kind of screwed it up.